Ladies and gentlemen, dear colleagues, let me start by thanking the organizers for inviting me to this conference. It's a real honor to be here among such a group of inspiring academics, and I am really happy to be able to present and discuss current issues on company law. As we already seen, there are so many issues that should be discussed and talked about regarding company law. And today, with the digitalization, electronization, and the advancement of artificial intelligence, it is even more important that we talk about these new technical developments, also in a connection with law. And it is also crucial to see whether current law, not in company law, but also law in general, can actually adapt to this new digital development. In my presentation, I will try to look on how Slovak company law is adapting to this new digital world, to this new digital era. The main question that I will try to answer is whether the current company law is sufficient and whether it is able to respond to these new digital trends. And I will show you some examples how the digitalization has already reshaped the corporate law and, in my opinion, will continue to reshape, but not only Slovak company law, but also national legislations of other member states. So I will also show you some examples from the European perspective. The practical importance of the technological and digital development was particularly highlighted during the pandemics, during the global COVID-19 pandemics. During this period, many member states presented or implemented various interim measures, which had facilitating the greater accessibility of digital tools during the life cycle of the companies. However, it must be acknowledged that all the member states or the national legislative approaches were different and differed significantly. But I believe this pandemic experience also showed to what extent the national regulation was able to adapt to these new challenges posed by the digital age. It is undisputed there has been huge efforts or partial efforts at the EU level to create a harmonized framework for the use of digital tools within the company law. The initial steps were already taken decades ago. For example, I can mention it was a directive on shareholders, exercise of shareholders' rights in listed companies, or the interconnection of business registers. However, these European efforts and endeavors aimed only to modernize selected issues, and it left room for further advancements. The advancements came in 2019 with the adoption of the Digitalization Directive. And maybe at first glance, it can be considered as a huge step forward. The scope of the Digitalization Directive is rather limited. So it focuses on the online formation of companies, online registration of branches, and online filling of documents. So again, it leaves room for other advancements. There are no harmonization of internal relations or exercise of shareholders' rights, which still are untouched. The primary focus of the Digitalization Directive is, as I already mentioned, it's the fully online formation of companies, which should be accessible at least to the EU citizens and at least for specific types of companies. This directive also aims to create a system of safeguards to combat the misuse of the digital tools and fraud in a company law. What this directive doesn't harmonize is the incorporation rules, so it doesn't specify the content of the template of the article of association or the design of it. But now let me introduce the Slovak solution of the online formation of limited liability company. On February 1st, 2023, it came into effect the amendment to the Slovak Commercial Code, which introduced the process of, we call it simplified formation, so simplified online formation of limited liability company, and it was a result of the implementation of the digitalization directive. I would like to point out that since October 2020, the registration, not the formation, the registration of any legal form of company to the business register in Slovakia can be done exclusively online. So in this standard procedure with online registration, all the documents must be filled in an electronic form. But what does it mean in practice? In practice, it means that the founders sign the article of association in a paper form. Then they scan it or convert it in an electronic form. And then the authorization by qualified electronic signature is provided either by the applicant, therefore the future directors, or the person entitled to file the petition to the registry, to the business register. But now, after the February 2023, the founders, they have two options, two possibilities. Either they use this standard formation, so they sign article of association in paper, and then they register the limited liability company online through an electronic form, or they use the simplified formation of limited liability by using electronic form of article of association. The special substantive requirements were added to the commercial code, and additional procedure requirements were added to the Act on Business Registry. Compared to the standard formation, the online procedure mandates the use of electronic template of article of association. The formula is available on the website of the Ministry of Justice of the Slovak Republic. The website is also in English. The formula contains 10 steps where the founders fill in the information. And through this simple electronic form, they form the company. It comprises only 10 steps, and the result is the article of association in the PDF format. And of course, not only this article association must be provided, but also other documents in the electronic form. But the Ministry of Justice doesn't provide for other templates. It provides only for the template of article of association. So let me point out the key differences of these two types of formation, the standard formation and we call it simplified formation, but you will see it is not necessary, the simplified. The first condition that must be met if we want to use the online formula for article of association is the maximum number of founders, which is stated to number 5. So if there are more founders that want to establish limited liability company, they cannot use this electronic form. The Slovak legislature justified this requirement by the experience from practice, which shows the low frequency of occurrence of a higher number of founders. However, in my opinion, it seems just like an unjustified national restriction. Also, the supplement of the business name can be only the shortcut of the LLC, SRO, which stands for Spoločnosť s ručením obmedzeným. There cannot be another supplements for the business name. Another distinction is that the shareholders' contribution must be only in cash, not in kind. But this is the condition that is expressly presumed by the directive that the member state may opt in for this solution. There is also obligation for all shareholders to have a bank account, which is not the case for the standard formation. And there is also difference in the position of administrator of the contribution, because while in standard formation, a founder, a bank, and a branch of a foreign bank may become the administrator of contribution, in this online simplified formation, only a director, so only a natural person may become the administrator of contribution. Also, what is very different is that the representation of the founder in the company's formation is not possible. So it must be the founder who signed the article of association, but it's qualified electronic signature. So if this founder doesn't have the electronic signature, it can't form established limited liability company by this way. So it's not possible through attorney. Moreover, there is another restriction that this simplified procedure limits the number of business activities which this limited liability company may carry out. It limits to 15 activities, and these 15 business activities must be chosen from the list of 73 free trades. So no craft trades, no regulated trades, so no other activities, for example, like a practice of attorney, psychologists, translator, architects, they cannot form the limited liability company with this online procedure. Also, the law poses a stricter requirement on the integrity of the natural person who shall become the director of the company, because while in simplified online procedure, an absolute integrity is required, in the standard formation, the integrity of the director is limited to certain types of criminal offenses. It is argued that this stricter requirement for integrity aims to achieve simpler, faster, or effective economic start. Moreover, with this online procedure, the supervisory board cannot be established. So therefore, many of you may ask, so what's the benefit of the simplified procedure? Maybe it's the cost, but I would answer simply no, because regardless of the process, the cost of the registration is the same. It was 150 euros, now it went up, and the cost for the registration through the court is 220 euros. And the period to register the company is 2 working days, so there is no difference. As we can see from the conditions, the initial shareholder autonomy, it's very restricted if they want to use this electronic form of article of association. However, once the company is registered, the article of association could be adapted to the purposes of the shareholders. Does the new simplified procedure have any benefits? This comparative analysis of requirements and conditions, in my opinion, relieves a paradox, because while the online formation aims for simplification, for attracting foreign investors, it imposes stricter rules. So simplified online procedure cannot be used for every formation of a limited liability company. Therefore, it is also questionable whether the Slovak solution really meets the intentions of the European legislator. For now, I couldn't find any statistics regarding the use of this article of association, of this electronic article of association, but maybe later on we'll see if it is really used in practice or not. I would like to mention also one other novelty. Since November 1st, 2023, it is possible to file a petition for the registration of a limited liability company by notaries, which are the external registrars. They verify the fulfillment of all legal requirements, but they are also able to execute the entry to the business registers. For now, it's available only for limited liability company, not for their transformation or cross-border transformation, change of legal form, but since January 2025, it will be able for the notaries to provide also the services for other types of companies and to registers, for example, joint stock company. Which is very interesting is that while before the fee for the registration was 150 euros, even for the registry through courts and through notaries, now when the law was changed and the fee was changed to 120, the act of the notaries was not changed, hasn't changed, so the fee for the registering limited liability company through notary stayed at 150. So it's more expensive to register a company through court than to the notary nowadays. I will move from the initial stage to the life cycle of a company, and let me tell you a little bit more on the impact of the digitalization on companies' internal relations, with an emphasis on private companies, because they are the cornerstone of the Slovak economy. The key issue here is the possibility of electronic participation of shareholders at the company's general meeting. Nowadays, at the EU level, it is, of course, enabling, or EU company law is enabling electronic participation in shareholders' meeting only for listed company. In August 2022, there was a report from the informal company law expert group regarding the virtual shareholders meeting and hybrid shareholders meeting in private companies. So the issue was already addressed, but there was no initiative taken at the EU level further in this topic. Currently in Slovakia, there are no general rules on virtual shareholders meeting, so it is assumed that it is forbidden to have a purely virtual shareholder meeting or the meeting with electronic participation admissible for private companies. Exception, of course, is listed joint stock companies because of the implementation of the directive. The Slovak legislature introduced interim measures during the pandemic, so it was able to participate at the shareholders meeting in private companies via electronic means of communication. However, these interim measures were only of a temporary nature, and they are not in practice in force anymore. But I believe that this experience should lead to the permanent change, and soon we might see a change because the initiative on the recodification of the Slovak Civil Code and company law shall waive the requirement of personal participation at shareholder meeting and offer technologically neutral provision. However, currently the work on recodification process is somehow postponed, so we'll have to wait for the paragraph version of it. And the last concept that I would like to mention is the so-called virtual registered seat. And nowadays, with more companies operating in digital environment, the effectiveness of classical company law requirements for incorporation must certainly be challenged. Currently, all member states require physical location for registered office. In Slovakia, the founders, when setting up a company, they must demonstrate a proper relationship to the real estate situated at their address, provided as the registered seat. The concept of virtual seat has a little bit different meaning in Slovakia, because, for instance, now in Slovakia there are several services that provide the possibilities to set up so-called virtual office. In general, these virtual seat services consist of arranging companies' register office by setting up a mailbox or a post box. And many companies are therefore registered in prestigious addresses, for example, in the capital Bratislava, where they do not actually operate, but they have their register seat as a mailbox. This situation doesn't simply indicate any illegal activity. But we can go even further regarding the virtual register seat, and we might think about creating a corporate seat that would be available only virtually, so without any physical connection. The use of virtual seat may have a positive impact on the businesses of the SMEs or the startups that operate purely in a virtual environment. On the EU level, there was in 2029 an initiative of the EU Commission that called Upgrading Digital Company Law. And this initiative, I cannot say introduce, I would rather use the word mentioned, the concept of complete virtual register office, because this initiative didn't provide it for any hints or any detail measured in this matter. However, after the impact assessment report from the EU Commission, this concept was discarded because of the political and legal feasibility. The concerns included facilitation, the operation of shell companies, the money laundering or the fraudulent behavior. Also, this concept raised questions regarding applicable law and also the way how official documents would be served to these companies. Therefore, for now, there are no legal framework in place in the EU or in Slovakia regarding the properly virtual seat. However, to my knowledge, there is only one proposal in Lithuania where where the proposer is discussing this virtual register seat, which should be the email address in a state-owned digital system, plus the name of municipality. So it's not actually the pure virtual registered office, but is some kind of hybrid form. So to sum up my key conclusions from the presentation, I think it's really important that our company law, not only Slovak, but also from other countries, really keeps up with the digital innovation and technical development and shall adapt to this innovation, which could facilitate the life of companies and the founders and the shareholders. Thank you so much.